Good morning. Happy Wednesday. I did a video on Chilli's motion to recuse the judge yesterday in his Las Vegas Metropolitan Police Department case. To recap his motion provides two citations to authority. Remember a typical motion, it's going to state what they're asking for, and then it's going to have a memorandum of points and authorities in it. The memorandum of points and authority is going to state all the facts, state all the law, and then apply the facts to the law. Weirdly, Chilli's does not do that. He has one citation to a case that this particular judge made a decision in, where this particular judge decided that because there were allegations of excessive force under Nevada's laws about discretionary immunity, that the excessive force claims that the officers were not entitled to discretionary immunity under the excessive force claims. The discretionary immunity is a Nevada equivalent, essentially, of the federal qualified immunity, and it applies to the Nevada statutes. For some reason, Chilli thought that the court gave a different opinion in that other case, but it didn't. The issues that the court did not extend discretionary immunity to were the issues of excessive force under state law claims, and the issues in Chilli's case where the same court did not extend discretionary immunity to the officers were for the state law claims that involved excessive force. So it did not say what Chilli thought it said. So it's weird that he would have cited it. I think he thinks he got a gotcha on the judge, but the two decisions are entirely consistent with each other. The only other citation he made was 228 USC 455A, which is a statute that governs the recusal of a judge. But he doesn't explain it. He doesn't exactly say how or why. All of Chilli's examples of bias on the part of the judge stem from decisions made in the particular case by this particular judge. So having reviewed the allegations that Chilli made, and Chilli doesn't understand the difference between a fact and a conclusion of law. He doesn't understand how the judge can determine probable cause when that's what the judge does in summary judgment. That's what the judge does. The judge will determine probable cause, and what the judge will do is say, could a reasonable jury decide that there was probable cause? If a reasonable jury could not determine could not find that there was probable cause, if it would have to be an unreasonable jury or an unreasonable finding by that jury, then that's the standard the judge uses, and the judge laid that out in his order on the motion to dismiss, that was the standard. Could a reasonable jury find, based on the facts before him, that any of this stuff was not necessarily true, but could a reasonable jury find, based on the facts alleged by Chilli, if he managed to prove them, that a cause of action existed, that Chilli should recover? And that also applies to probable cause. So it doesn't make sense. But all of Chilli's citations, all of Chilli's references were to pleadings that were in the case. He doesn't state or allege that there's any sort of outside knowledge that the judge has of him. He didn't allege the judge had watched more of his videos or something like that that's prejudiced the judge. He didn't do any of the things that he was supposed to do. Remember my example from the Springer versus the 7th Judicial District Court of New Mexico, where if Springer could have alleged that he went to a bar and he saw the judge hanging out having a beer with the defendant, Mercedes, Poff, any of the other ones, then that would be something that he could actually allege and say, like, they're friends outside of, you guys are friends outside of of court, and so you're biased in the defendant's favor, and you're biased against me because I'm not your friend outside of court and they are your friend. That's something that a judge would have to recuse themselves on. But saying that you ruled against me is not something you recuse a judge on. Saying you ruled against me and you should have ruled in my favor, that's something you file an appeal on, or you file a petition for writ of mandate or writ of prohibition on, or a motion for reconsideration. That's what those mechanisms are for. Recusing the judge because they ruled against you is entirely the wrong thing to do. It was wrong for Springer's attorneys to do it. It's wrong for Chilli to do it. I never would have suspected I would say this, but Springer's attorneys did a better job than Chilli did, but only marginally in their motion. It's pretty sad. Another thing that Chilli raises is Chilli somehow thinks that he's entitled to a Rule 56 notice. The only Rule 56 notice that I'm aware of, mostly in the Ninth Circuit, I'm sure that other circuits have it. Rule 56 is the summary judgment, Federal Rule of Civil Procedure for summary judgment. The only notice that I'm aware of that deals with Rule 56 that a court is required to give is for pro se prisoners. Specifically prisoners, not any pro se plaintiff, but a pro se prisoner who's a plaintiff. And it's just a form that says what they have to do to respond to it. I don't know why Chilli thinks he's entitled to that. He's not a prisoner. He's not. He's aware of its existence, which, I mean, that in itself should indicate that he has the knowledge of it and what would be in it. But he's not a prisoner, so he's not entitled to it. I don't understand it. So it was a nonsense motion. It is not going to prevail. He's not going to prevail with it. So I guess we get to look forward to that. I also noticed when I was looking at it, the judge had granted, Chilli had also asked for a 7-day unopposed motion for, I think, a 7-day extension of discovery to set the discovery, to have the discovery conference for a discovery plan. I don't remember what the 7-day extension was exactly for. It was related to discovery. I think it was to submit a discovery plan. But the judge granted that because why wouldn't the judge do that? So it was a nonsense. The motion to recuse a judge was a nonsense motion to recuse a judge. It's going to fail for exactly the same reasons that Springer's motion to recuse his judge failed. If the judge is ruling against you, then your remedy is to file a motion for reconsideration, a motion for or a petition for a writ of some sort, mandate or prohibition, and or file an appeal. Those are your options. Like you don't get to get a do-over because you don't like the judge's decision. Anyway, that's all I got for you today. Thank you for watching. Have a great day.